the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Okay, are all counsel in this case on? I think I see more counsel than are registered here.
Yes, Your Honor. Teresa Norris for Marion Bowman.
And Mr. May?
Present, Your Honor. Thank you.
Okay, why don't we begin with Ms. Norris? This is on the first case of Bowman versus Sterling.
Thank you, Your Honor. May it please the court. This is a capital case where Marion Bowman was sentenced to death following convictions for murder and arson third in Dorchester County, South Carolina. The state's case was built on primarily on biased witnesses with strong motives to lie. There were multiple people charged in the case, including family members. 7 people were charged, 5 testified. The conviction and death sentence were also based on the state's non-disclosure of evidence, despite claiming an open file policy. The solicitor explicitly said on the record that he, several months before trial, when they were arguing motions, that he had an open file policy and anything else, and that the defense had already looked at anything else that came in, that he would fax it over immediately. That is in the district court docket number 11 at pages 76 to 78. Despite claiming an open file policy, the solicitor did not provide all of the information that was available. There were 3 primary witnesses for the state. One testified to being a direct witness to the murder, the actual shooting of the victim. He also provided aggravating details about her, saying that she was scared, pleading for her life, and saying, "Please don't shoot me, I have a child." The second
counsel, I think we're fairly familiar with the record. If you want to move directly to your legal arguments, that might save you some time.
Yes, Your Honor. Of course, with respect with a Brady claim, we must address whether it has been suppressed. In these particular issues, particularly with respect to the mental health report of Taiwan Gadsden, who testified about the murder, Mr. Gadsden was examined in his own case as he was charged with murder on a competence evaluation. A report was provided, and that was not provided to defense counsel, despite the solicitor admitting in post-conviction that it did contain impeachment value. The state court and the district court said that there was no suppression of that because the defense could have discovered that by due diligence. We submit that there is no due diligence requirement under Brady. Banks versus Dratke makes clear that a rule that says a prosecutor may hide and a defendant may seek is not tenable in a system bound to accord defendants due process of law.
Explain to me how you believe that mental report would be used at trial.
Well, Your Honor, it included specific.
Well, I know he had seizures and maybe some memory failures, but how would a lawyer use that at trial to cross-examine the witness?
Well,
we're talking about Gadsden, right?
Yes, Your Honor. You would do that basically as the post-conviction counsel did. Gadsden testified in post-conviction. He was asked, "Do you have memory problems? Did you say this to me?"
I understand, but when he testified to things that he did remember, the question is the most that could be happening, he'd leave something out and he wouldn't know about that fact. But there was no suggestion or no circumstance historically that was alluded to that could bring this to light. In other words, this was not something where he said one thing and he says, "Oh, I forgot," or whatever. He did recant on the with respect to the SAM memo, but that's another issue altogether. I'm just trying to figure out how you would use it and how it would be to affect. I mean, he was cross-examined on his alcoholism, wasn't he?
Well, he was cross-examined on being drunk that day, but
Yeah.
Your Honor, in the.
I mean, that's more powerful, if anything, than the fact he may have had an epileptic fit or lost a seizure or something, a lost memory. When he testifies, he actually sees something or witnesses something. He obviously wouldn't have been in a seizure.
Yeah, maybe.
There's no evidence. Well, there's no evidence from anybody or anything that suggests that. I mean, these are intermittent when they happen, and I think a person who's in such a seizure is, I guess they know that they are in it, but.
Well, Your Honor, I would submit that if you are blacked out, you don't know when you're blacked out. But beyond
But then you won't testify to something that you didn't witness. In other words, he testified to witnessing something. If he's blacked out, the only argument would be he fabricated it. But he was there and functioning, and there was a continuum of historical conduct. I just wonder how it would be used. And it seems to me the most powerful aspect would be some kind of drug or alcohol dependency, but the drugs was marijuana. There's no suggestion he was under influence then. There was a suggestion he was under the influence of alcohol, I guess.
that suggestion is missing, Your Honor, because the defense didn't have the report where he admitted that he smoked 6 months of cannabis a day. You add that to the alcohol, it's a different picture.
Why is it different? I mean, if he's high on cannabis, what's the indication there other than the same indication that if he's intoxicated?
Your Honor, I submit.
I mean, we're talking about, a materiality affecting a trial and anything adverse. I'm suggesting that in this argument, we assume that there were non-disclosures under Brady with respect to the SAM memo and the pending charges on Johnson and this mental aspect with respect to Gadsden. Let's start with that. But the real question comes is how would a lawyer representing Bowman have used it, and how would that have affected the trial, if at all?
Well, Your Honor, it's more than just the trial. The court also has before it, because Brady is a sentencing case itself, even if it's not material for the trial, it can be for the sentencing. And we certainly submit that Bowman was denied the fair trial, but also the fair sentencing. But in addition to the impeachment value that could have been used from the mental health report, there is, of course, the SAM memo. And the state court there, along with the district court, essentially said that it was enough that the defense had a Davis note, but there are material differences in the note that Davis himself wrote.
Well, counsel, let me ask you how this helps you in view of the testimony at several places from trial counsel who represented that he would not have called Gadsden even with this because it was too dangerous, that he would finger Bowman as the person who had him write it, and that would conclusively convict his client. And he answered several questions about being in the same boat, whether he had the memo or not. I'm having difficulty understanding, based on particularly on the testimony of trial counsel, how this could have been material, particularly if it wasn't going to be used.
Well, Your Honor, he also testified based on the memo that was suppressed. It included information that Davis had said that Gadsden confessed to being the killer in front of at least 4 to 5 other people. Defense counsel.
Right. We can all read what that says, but still you have his testimony that knowing all that, I couldn't take a chance of using it. Well, I couldn't put him on for that.
Your Honor, he was referring specifically to Ricky Davis, but he testified explicitly that he would have investigated further if he had had that information.
But he also testified that even with the memo, he would not have put him on. He said for purposes of that decision, the memo didn't add anything. He had the note, and exactly what Judge Agee is pointing out, and it's pretty obvious. It's a real risky proposition to put somebody on who said, "I was told by the defendant to help him out and to confess, and I just did it for that purpose, and I recant. That's not true, and it actually was him, and I saw him." I mean, that's pretty dicey as a lawyer.
Well, Your Honor, I submit that it is what a reasonable lawyer would have done in this situation, and a lawyer's
and what a lawyer said, the actual lawyer said he would not have used. It's not even speculation. We have direct evidence on that, uncontradicted.
Well, Your Honor, I think it's also uncontradicted that he said that he would have investigated further and looked for other witnesses.
Well, let's assume every one of those witnesses was told by Gadsden that he did it. I mean, Gadsden comes back and says, "Yeah, I did that, but I did it because the defendant told me to, and I was trying to help him out." And, and the truth of the matter is, it was he who shot, and I witnessed it. I mean, it's dynamite.
At that point, Your Honor, it's for the jury to decide. Yes, all these ifs, ands, and buts may have happened, but the defense would have had all the available information. The jury could have made the decision. And again, we're not just talking about the result.
Well, I'm assuming for the purpose of the discussion here that there was a non-disclosure that fulfills Brady's first prong. The real question I'm focusing on is the three things that you focus on. Would they have made a difference in this case? And it's quite a push. I mean, I really want to hear what you're saying on that, but that to me is where the rub is in the case, what we have to decide.
It certainly could have made a difference in sentencing. It is clear that, yes, Marion Bowman may well have still been convicted of murder and arson if everything went the wrong way.
Counsel, let me ask you specifically about sentencing. Where was that argument made below?
Your Honor, I submit that it's included within the Brady argument itself. When you argue he didn't get a fair trial, you're automatically including sentencing, because without the trial, there is no sentencing. And Brady
But you never made a specific argument as to the effects on sentencing. Is that correct?
I think that's correct, Your Honor. The post-conviction counsel was focused on guilt, innocence, but again, Brady itself, Banks is, both of those cases are cases where fair trial was asserted. The courts rejected materiality for guilt, innocence, but found materiality and reversed the sentencing.
Right, but that's a different issue as to whether a claim as to sentencing was raised in those cases as opposed to here, where there's no, certainly there's no explicit reference in the lower court that a claim is being made as to sentencing.
There is no explicit reference, but as I said, Brady itself is a sentencing case. It was
play it out. We're on sentencing now, and the question is, you're going to try to do the same thing. You might get the jury even angrier because the guy's more culpable. Now you have a defendant who is not only committed murder, but is covering up by directing his colleague to, in other words, I'm not sure that it makes your client more sympathetic on sentencing than it did on the guilt phase. And
well, Your Honor, there is another aspect of the Brady claim, and that is respect to Hiram Johnson, who the solicitor argued had no motive. He's the one witness that the solicitor says no motive to lie in this case, and he had pending charges in front of the same solicitor that were never disclosed. They're not even on the rap sheet that was
and the
given.
fact that he's charged affects his credibility. How do you get that in? In other words, somebody's charged and he's falsely charged, or he's presumed innocent, and you're going to say he's lying because he's been charged? or imply that?
You can always impeach a witness with bias or any motive, and having pending charges a desire
Would a
to
court
plead
let in?
the prosecution.
Would a court let in information about pending charges on which there's been no adjudication of any kind?
I submit in South Carolina, yes, you can cross-examine a witness based on motive to lie and pending charges where you want to please the exact prosecutor that is questioning you
What were the
in
charges?
the courtroom.
What were the
And,
pending?
you know, there doesn't,
Excuse me, what were the pending
he had
charges?
charges of receiving
Pardon me, what were the-
stolen goods, burglary second, and grand larceny. So he faced up to 15 years on just the burglary second. So, Your Honor, I submit that it could very well make a difference in sentencing, as the solicitor relied on his testimony there fairly heavily. I see my time is out, so I will.
Okay, I think we understand your points though, but you do have rebuttal, and we'll come back to you. Okay, Mr. May?
Thank you, Your Honors. May it please the court. Your Honors, under Brady, it's a simple test. You have to demonstrate that there's favorable evidence that is either exculpatory, impeachment-based, or mitigating.
Well, I gather here, just to cut through it all, we have three aspects that were not disclosed, and the defendant basically says they affected either his trial or his sentencing. And so why don't you start off from that platform?
Certainly, Your Honor. On that platform, there's three different claims of Brady. Two of them do not provide evidence that the state suppressed the evidence in question. All three fail on the question of materiality. Now, jumping first to the Hiram Johnson charges. That is the only claim in this case that has been found, reasonably so, by the PCR court and the federal courts thus far, that there was a suppression of the evidence in question. And that is the case. Charges like these should have been provided to the defense. However, looking at the record, there's a couple of reasons why you cannot get even close to finding that this would be material for purposes of reasonable probability of a differing result at trial. First, if you read the record closely, there was an arrest warrant out for Mr. Johnson, but he was not even arrested until after he had already helped the police with information in the case. He provided a full a statement to police demonstrating what had happened that night, what he had seen, that on April 5th, but he wasn't arrested until May 29th. So the argument that the defense could somehow use that information to chip away at his credibility, that there might be some basis for bias because he has pending charges, is dwindled considerably when you say, well, he was already helping the police before he was ever even arrested. So that's number one, goes to materiality, because it would demonstrate to the jury that he might have pending charges, but he was helping beforehand. The second is, if you look at the evidence in this case, there's just no way to get to materiality. You've got three different witnesses that demonstrate petitioner gave his intent to kill victim. You've got a witness that saw the crime. You have three witnesses that heard him confess, and you have a witness that saw him dispose of the body by setting.
Counsel, is this your overwhelming evidence argument?
Yes, this would be the overwhelming evidence, and it would go to all three of these claims. But you've got three different witnesses that either heard him confess, saw him do it, or saw him get rid of the body and the car. And the coup de grace of all evidence in this case is that Bowman's own family members disposed of the gun by throwing it over the Edisto River, and that gun is only in this case as evidence because they helped police conduct an underwater dive to recover the murder weapon that matched the bullets, the shell casings at the scene. There's no way to get beyond that. There's no way to demonstrate a reasonable probability of a different result when that is the evidence that you have in your.
Counsel, am I correct? This is the case where the defendant's sister testified that he said he was going to kill the victim the day that she was murdered. Is that correct?
That's correct, Your Honor.
Okay.
It's actually two different sisters, Kendra and Yolanda, that both basically the same thing, that they heard practically the same thing out of his mouth that day. Your Honor, moving to the Sam memo, Brady requires the disclosure of information, not explicit specific documents. And in this case, the defense had the information that is pertinent from the Sam memo. That being that supposedly—
Is this an argument that you didn't violate Brady in failing to disclose? Shouldn't that memo have been disclosed?
We would argue not, and we would argue that the findings of the PCR court and the magistrate and the district court finding to be reasonable, that it was not suppressed. The information that comes—
Well, it wasn't turned over, was it?
It was not turned over, but the failure to turn over does not equal suppression for purposes of Brady.
Why?
Because Brady requires the evidence to be either exculpatory or impeachment or mitigating. And in this case, the information that is exculpatory or impeaching from the Sam memo was in the handwritten note that had already been turned over.
There was more in the Sam memo. There was other people involved that could lead to investigations and so forth. I think you're picking your hardest problem.
Well, Your Honor, I would argue, and based on the rulings of the prior courts, the information that's additional in the Sam memo is the context in which Bowman said, "Hey, write a handwritten letter saying what Gadsden confessed to," and none of that would be exculpatory for Bowman. It's just Bowman's comments.
Well, counsel, if we assume that the Sam memo was suppressed, what's your argument then?
If the court were to assume that the Sam memo was suppressed under Brady, you're still fighting a ridiculously uphill battle on a materiality claim. Because the nature of the evidence in question simply doesn't provide the defense much at trial were it to be used, mainly because I argued that all of the exculpatory impeachment evidence from the Sam memo was already in the defense's possession. They could have cross-examined Gadsden on whether he supposedly confessed to Ricky Davis. And as the court pointed out, Ricky Davis recanted his testimony. The defense actually took efforts to further investigate the supposed confession from Gadsden by going to Ricky Davis. And if they claim they want to find those other 4 or 5 people that supposedly heard this confession, the fact is when they tried to investigate this part of this particular evidence, they met a brick wall in Ricky Davis saying, "None of that's true. Your client told me to make it up." So it's not that there's nothing that really prevented them from getting to anything, because as far as their witness is concerned that providing this information, there is no information. But nonetheless, they still had the handwritten note, and they could have used that at trial for purposes of cross-examination to simply ask Gadsden if he had confessed. And as the court had already pointed out, it is a stick of dynamite to call Ricky Davis and try and go any further than that with the risk of demonstrating that their own client asked him to make up some of this information. And ultimately, the PCR court's findings to those facts and the application of law in this matter were reasonable. And that is really the only question that this court is here to decide is, was the federal law applied by the PCR court?
On that point, counsel, there's been a little discussion about cumulative materiality. Is that something that we would need to address? And if so, would we review that for unreasonableness, or would we have to review that de novo? What's your position on that?
Certainly. As the current holdings stand, there's only one claim that was found to be suppressed by the courts. With that being the case, there isn't a cumulative effect argument to be made because there's nothing to accumulate.
Well, why don't you assume, as the question was postured, which is there is an argument that it was cumulative, and the question is how do we address it? Because it's basically an additional argument, isn't it?
Certainly. And if this court were to find that one of the other two claims was a suppressed piece of Brady evidence, then you would have a cumulative argument to consider. But you're still left with a de novo review and a materiality argument that's just not going to cut mustard. If you look at these three pieces of evidence, they don't provide the defense much of anything to get to a jury to suggest that the evidence they've heard of guilt would somehow corrode the verdict that they reached. And Your Honor, just to...
Well, so counsel, is the bottom line of your answer there that the evidence is overwhelming and therefore the cumulative effect is insufficient to undercut the verdict? Or, I mean, what I'm not exactly sure what you're arguing there.
Certainly. There is overwhelming evidence in this case, massively overwhelming evidence in this case. And if you're looking at these three individually, they fall well short. But even if you're adding them all together, even if you add all three together, they don't collectively, cumulatively, provide that much for the defense. You're talking about a SAM memo where the information in question was already provided, but all it really does is, did you, by cross-examining Gadsden on whether he had a confession, he's going to deny it, presumably. That's pretty much the end of that explanation, because counsel said he's going to be in the same boat with his Ricky Davis witness saying that he's going to recant and demonstrate that his client hadn't made it up. If you look at the Hiram Johnson charges, you're talking about a witness who didn't see the crime and didn't see the disposal of the body, but heard a confession and demonstrated that he saw the Bowman with the stolen car and with the gun in his lap. If you're telling the jury, hey, you shouldn't trust this individual getting anywhere as far as demonstrating to this jury why there is not enough evidence to convict Bowman. And to the third, the Gadsden mental health report, there's no evidence that Mr. Gadsden was under the influence of cannabis at the time of this crime, and the cannabis doesn't really go to so much to credibility as it would just character. We want to call this guy a cannabis head, so maybe the jury won't like him as much. The other evidence in the mental health report says explicitly that there is no memory impairment other than verbal memory, and a brief search just demonstrates that you don't always remember what you're told under that circumstance. That is not going to convince a jury that they shouldn't trust Gadsden because he witnessed and could describe in detail how a murder took place along the street on Nursery Road. That's not going to erode anything in the eyes of a jury. All of that collectively put together doesn't provide any kind of evidence that would erode the confidence of the verdict in this case. So cumulatively or independently, they're still falling well short of the bar. And Your Honors, I would just add, I haven't spoken a great deal on the Gadsden mental health evaluation. There's been some argument in this case that that Banks stands for the premise that there is no due diligence standard to be placed on counsel. Banks does not stand for that. Banks' decision, as this court has found in multiple cases, just one second. Originally in U.S. v. Kelly, then Fullwood v. Lee, and then again in U.S. v. Maximo, Cantone, George, and Hicks. This court has never found Banks to be a controlling authority, that there is no due diligence, equal opportunity.
Yeah, but now you're suggesting that defense counsel should, with respect to all the government's witnesses, somehow start searching for mental health reports or other types of things. The principle of due diligence really focuses on the notion that counsel, a prudent counsel, would normally engage in the investigation and discover the information. But I think the Supreme Court is pointing out that there's a certain limit to that. The breadth of that, the idea that you have to go hunting around when there's a constitutional duty to disclose, is the message that's being conveyed.
Well, Your Honor, I would respond in a couple of ways. First, in this case, this is not evidence that an attorney would have to go snooping around to find out that it exists. His own client had been subjected to the same mental health evaluation just a couple of months before, and it produced a multi-page report of Bowman's, obviously his mental evaluation, but also how he interprets things that took place that day. If an attorney is holding that kind of document in his hands for his own client and recognizes that there is a co-defendant charged with the exact same crime and for the exact same charge, it should dawn with under due diligence that that type of evidence probably exists for the co-defendant as well.
So you have a 10-person conspiracy, and you're suggesting that counsel should be going around looking for the mental health records of the 10 conspirators.
It would be under due diligence looking to see if such a report had been ordered, and that could have been easily determined by simply opening the Gadsden case file at the clerk of court's office. And
I don't know how many cases you've represented defendants and engaged in that kind of, I mean, when you're in a capital case, it's intense, it's a lot of work, and the notion that you have to start doing background checks on every witness and every co-defendant when the government has it right in its file, that's a pretty heavy load to carry, argument to make.
Your Honor, it could be cumbersome in some situations. In this situation, it's not particularly cumbersome. This was the only eyewitness to the case, and if defense counsel is doing his job, he would, I think, take at least limited efforts to look at that case file and see if the document that exists.
Counsel, that seems more like an ineffective assistance of counsel argument that post-conviction counsel would have raised. I don't think they did, but that's different from whether or not there's a failure to disclose.
Yes, Your Honor, it could be couched in that way, but it goes back to equal opportunity of finding the evidence. And as if you look at, and this is certainly not a mandatory ruling or anything of that nature, but if you look at the Wright and Miller Federal Practice and Procedure, they actually list under Brady materials that evidence equally available to the defendant by exercise of due diligence means that the government is not obligated under Brady to produce it. And then they provide the footnotes, all the circuits that have held to that kind of ruling, and you've got the 11th Circuit, the 4th Circuit, the 8th Circuit, the 9th Circuit, the 7th Circuit, the 5th, and the 6th Circuit have all had cases that have reached that kind of ruling. And I would point out that while the defense relies on the 3rd Circuit reaching a different conclusion, it did not reach that conclusion as a result of Banks. It reached that conclusion in 2016 after producing multiple opinions that demonstrate that it held that rule after Banks that came out in 2004.
Well, counsel, if we assume the Gadsden mental health report was suppressed, what's your materiality argument there?
That there's practically no materiality at all for the Gadsden report. As we discussed, demonstrating someone that smokes cannabis doesn't demonstrate a lack of credibility when the evidence shows that he wasn't under the influence of cannabis at the time. For a guy, for the rest of the report that says, well, he suffered seizures and blackouts. Well, The report also demonstrates that that was only 3 times, and none of those 3 times were the day of the crime. And if we want to talk about the hearing of a beeping noise or hearing a voice, that doesn't demonstrate a lack of memory or an inability to tell the jury what he saw that day. And there's no findings in that report that demonstrate Gadsden is coming under the influence of grand delusions and seeing things that aren't happening. There's nothing in that report that truly takes Gadsden's credibility out of the minds of the jury. Now, he was cross-examined for the purpose of saying, hey, I was drinking that whole day. And that, as the court has pointed out, is far more effective than demonstrating that he likes to smoke weed regularly. And that's far more helpful than demonstrating, well, he heard a voice and here's a beeping noise. He's in prison. Some of those things might actually be true. We don't know. But it doesn't demonstrate that there's a lack of credibility for Gadsden. And for all 3 of those issues, materiality is lacking to a substantial degree. And for that reason, the finding of the PCR court that was reasonable in both fact and law, and the judgment, the conviction should stand.
Thank you, Mr. May.
Thank you, Your Honor.
Ms. Norris.
Thank you, Your Honor. May it please the court. Mr. May addresses repeatedly the trial outcome. He never got to, even if Mr. Bowman still would have been convicted, would the sentence have been the same? I submit, as Judge Rushing asked, the cumulative nature of the material of the suppressed items must be considered not only to the trial, but to the sentencing itself. Here you have Gadsden, the only witness who says that that I saw Mr. Bowman shoot her. It is clear based on all of the evidence that it is just as likely that Gadsden was the shooter and Bowman was the accessory. Gadsden was the star witness, and it's more than just is his memory impaired. Number one, he has a motive to lie. It's already in the record that he was charged with murder, could have been, the state could have sought the death penalty. He got a deal for a maximum of 20 years as opposed to death or life. You add to that, he has the motive to lie, but even assuming that the jury would have found him truthful, it's more than just, are his memories complete? Someone who is so intoxicated.
Let me ask you something that's a more fundamental before you leave. I've been wanting to ask you what your view on this is. The state court, PCR court, addressed your claims on the merits, going through and providing an explanation. And the standard when the state does that is a very high standard for us. Basically, Congress and the Supreme Court have told us to lay off if the state has decided it. And the only way we can reverse a finding of fact is if it's off the wall, so to speak, even if we disagree. As you know, they beyond any possibility for fair-minded disagreement. So it's not a disagreement on what they did. It's the notion that nobody could reach that conclusion, so to speak. How do we address the PCR court? I mean, are you making the argument that they basically were out of bounds?
Your Honor, the post-conviction court did adjudicate for purposes of 2254 the question of materiality as to the trial. The court did not address sentencing. And because of that, Johnson versus Williams and Wiggins says that if the court does not address the prejudice or materiality.
Was it presented to the PCR court, the sentencing?
Again, Brady is a sentencing case. You cannot.
No, that's not my question. My question is, was that argument presented to the PCR court?
Was it explicitly argued? No.
But it would affect the sentencing.
By saying.
In other words, materiality is a big part of the Brady. And the question is, in arguing materiality, did counsel argue to the state court that it would have affected the sentencing?
No, Your Honor, they did not. But I submit that that is included in the question. And here, this is not a even if.
Yeah, but the counsel, the cases that you reference, including Brady, I mean, it was clearly sentencing was specifically raised, and that seems to me a fairly significant distinguishing factor here. Is you're using cases where sentencing was the issue, and if it wasn't raised to the PCR court, I don't think that you can expect them to address it sua sponte.
Even assuming that EDPA applies, 2254 deference applies, this is not a highly aggravated case. The state only used the trial evidence and testimony of which Johnson, the man who had pending charges, and yet the state said no motive to lie. He's the person that says that Bowman confessed to this murder laughing. That is a centerpiece of the state's argument in sentencing, that Bowman is a cold-blooded murderer, he enjoyed killing, etc. There's only the trial evidence, there's victim impact, and nonviolent prior convictions, as opposed to the mitigation of this is a 20-year-old kid, essentially, without a whole lot of aggravation. And in South Carolina, this jury, as every jury in a capital sentencing, was instructed you can give life for any reason or no reason at all, just as a matter of mercy. Certainly, I submit this would have made a difference to sentencing, even under the EDPA standards. I see my time is out. Thank you.
Well, thank you very much. I think these arguments were well presented, and our practice, as you know, would be to come down into the well of the court or into your rooms and shake your hands. But you know, Star Trek, we used to beam people around. Maybe we'll come around at some point and be able to beam ourselves to you and shake hands. But we'll have to, for now, we'll have to just thank you for your arguments and welcome you to the Fourth Circuit and hope you come back.
Thank you.
We'll proceed on to the next case. Mumford and Mr. Melrose, you're up first.
Thank you. And may it please the court, my name is Mark Melrose, I represent the plaintiff in this matter. It is an unconstitutional use of excessive force for a law enforcement officer to shoot a motionless man who is merely possessing a firearm, investigating a nocturnal disturbance, and is not threatening the officer or others.
Well, you stated a lot there, and that's the whole case on appeal. So why don't you get into your argument as
Yes, sir.
to why you believe this officer didn't act reasonably in the circumstances?
Yes, sir, the threat to the officer.
Well, is that what the officer thought?
Your Honor,
The officer thought the man, Mr. Nibbs, was right behind the door with a gun ready to shoot through.
Knowing the facts that were available to Mr. Monford would not have acted as Mr. Monford did. This is not a case of misperception. The misperception cases that this court has decided all involve furtive or sudden movements or turns of the body or statements or other actions.
All right, let's give Mr. Monford his due at this point, and then we can argue it. I mean, he first of all came to a scene where there was a dispute between neighbors. He thought there were nails in the boards in the front. He was told the man was intoxicated. He said that there had been disputes between the neighbors. He knocked on the door, nobody answered, the lights were out. He goes next door and the lights turn on and he sees them turn on and says, oh, they're home. He goes back and he knocks on the door again. He hears a cuss word. He heard the footsteps coming to the door. He hears the gun being loaded. He thinks the guy's going to shoot through the door. In order to get away from that, he crosses the window with a flashlight and he sees the man there with a gun. And he fires, thinking he's about ready to be killed. That's the officer faced. Now tell me, should an officer stand there and defensive and not react?
Your Honor, that's essentially many of those facts are what the defendant argues and what
Not
Mr.
argues. This is the undisputed record. Tell me what fact was disputed.
Your Honor, taking some of those things, Mr. Monfort says he went to the house first and he announced twice before he went up the hill. None of the residents heard that or saw that.
He testified to that and nobody disagreed with it.
Right. It's the absence of evidence in that they didn't hear anything.
Well, he yelled. He said he yelled, and there's nothing to dispute that he did that. And then he went next door, and when the lights turned back on, he had assumed nobody was home. When the lights went back on, he's with the neighbor now, with Freeman. He says to Freeman, he says, oh, the lights went back on. He must be there. So the officer goes back to the house. And at that point, he hears the full movement. He hears the guy say F when he's being yelled at. He hears the footsteps coming to the door. He hears the gun being loaded. He instructs him to drop the gun. There's no indication that he did drop the gun, which really heightened the risk for him, and he thought he was going to be killed. Now, the Supreme Court last week had this Hammer case, which I think was less threatening to the officer, and the court summarily found immunity and sent it back to the Ninth Circuit.
What Mr. Monfort knew and what he testified to was that it was a civil dispute, that it was something.
What's that got to do with it?
Because
the point is he's threatened. He believes he's going to be self-defense.
I think it goes to the factors, the three-factor test, the severity of the crime at issue, whether there was the suspect or victim was trying to escape from custody.
There was no crime being investigated. There was a domestic dispute being investigated. During the course of the investigation, he's faced with a life-threatening situation. We're not talking about necessarily a crime being committed. That's irrelevant to what this officer did and reacted to.
Right.
I think you stay with what the officer, a reasonable officer in Mumford's situation, should have done.
Right. Your Honor, Mr. Monfort's testimony was that and the evidence most favorable to the plaintiff was sheriff's office was said one time, and that's a fact that the district court judge did not consider, because that's what Mr. Freeman, the witness, the ear witness who was nearby, said one time, sheriff's office. Immediately after that, Mr. Monfort hears the shotgun being racked. Immediately after that, Your Honor, Mr. Monfort has decided, based on our evidence, that he is going to shoot Mr. Nibbs.
No, you left out some critical facts. We hear the footsteps coming down to the door. We hear the fact that the gun is being cracked. We hear the most critical fact is that the officer instructs Nibbs to drop the gun.
Right.
And Nibbs doesn't do it.
Your Honor.
So now the question is, Mumford thinks the gun is going to be aimed through the door at him, so he has to get away from the door.
The problem with that, and this is why a jury needs to become involved, is Mr. Monfort gave him no time to comply with the instruction. There's two things there. The evidence is for the plaintiff that almost immediately, quote unquote, directly after, quote unquote, or automatically, those are the three phrases used by Miss Nibbs, the shots came almost immediately after the second put it down.
Well, counsel, can we go back just a little bit time-wise? Because my impression here was whether or not there's a factual dispute. And the factual dispute would be that Deputy Mumford gave testimony at some places that said that Mr. Nibbs at point-blank range. But you have an expert that testified that that could not be the case, and that Mr. Nibbs had to have been standing with the shotgun pointed upwards in order to account for the bullet wounds.
Yes.
So my question is that the factual dispute, that if taken in the light most favorable to the plaintiff, if the jury believed your expert, did not believe Deputy Mumford, was Deputy Mumford entitled to shoot a homeowner under these circumstances if the gun was not pointed at him.
That's correct, Your Honor. And that's the Hensley case also, and that's the Cooper case. If the homeowner is just possessing the firearm and is not pointing it at the officer, and Sheriff Holland admitted, and unless and until that weapon was purchased, we have a crime scene expert and we have a police use of force expert, all of whom opine that Mr. Momford's conduct was reckless, aggressive, and escalated the danger, and that Mr. Nibbs was shot while holding the shotgun.
Well, that part goes to a different issue. It doesn't really go to the factual question at the time of the shooting. What was Mr. Nibbs doing with the gun?
Yes, sir. And I agree in part. Partly the state law claims there's more of a totality of the circumstances under the Lee case, everything that happened leading up to it. With respect to the forensic, and that's the Scott versus Henrich case, because Mr. Nibbs is dead and cannot testify, the court is instructed to take a careful look at the forensic, scientific, and other expert testimony, which we presented 3 different special experts in 3 different areas of expertise to demonstrate that all that Mr. Nibbs did, taking the light most favorable to the plaintiff, was go to investigate a nocturnal disturbance. He got no closer than 6 feet to his front door, was standing safely behind a solid wooden front door with a shotgun in the Pledge of Allegiance position pointed in a safe direction. That's all that Mr. Nibbs did. He didn't say anything, he didn't move, and he wasn't given time to comply with this instruction to put it down by somebody that he couldn't see, didn't know if it was law enforcement, and there's no blue lights. Yes.
Counsel, can I ask a question about, you're describing, I think, we obviously have to take the facts in the light most favorable to your client, and you're describing Mr. Nibbs's point of view. And I think Judge Niemeyer was getting at the officer's point of view. Something that troubles me here is that the officer can't see what's going on. Many of the other cases we have, the officer can see whether the gun is pointing down or someone's coming towards him. And here, the victim is inside his own home, approaching to check on the disturbance. And what's your perspective on what it's reasonable for an officer to assume in that situation?
I think at that point, it's reasonable for the officer to assume that the homeowner is likely in bed, that there's been a civil dispute earlier in the evening. That's what he knows. And that he is likely going to get the homeowner up by shouting at a darkened house, sheriff's office one time. And that in rural Western North Carolina, a reasonable officer would expect a homeowner to likely have a firearm. And if a homeowner hears a disturbance, they're likely to bring their firearm to investigate a nocturnal disturbance. He's protecting his own family. There's children in the home and his wife, and he's protecting them. He's bringing it, but he doesn't threaten the officer. What changes, the only thing that changed after the shotgun was racked, is that the deputy moves from a position of safety behind a door to a position where he tactically blinds Mr. Nibbs with the light and then shoots him, even though Mr. Nibbs is not even pointing the weapon at him. And that's the facts.
That's true. There's also the officer saying, drop it at least once. And I take your point that the evidence in the light most favorable to you is that there wasn't much time to comply, if any. Right. The fact that he can't see if it's been dropped, that's what do we do with that factor? Is it even relevant because he's in the house and can't hear or see what's going on?
Well, a reasonable officer, to take the defense's position and their argument that they're making, their contention is that a reasonable officer, as soon as he heard that shotgun rack from within the house, could shoot to kill, regardless of what he saw after that. Because
the officer's position is not just that he racked the gun, he loaded the gun, but that when he heard that, he instructed him to drop it, and he didn't. And the officer also assumed that the door was not a safe place, that it was the most unsafe place because of the person inside would shoot through the door, thinking that's where where the officer was. And so, and I assume bullets can go right through the door. I mean, that's, so I think he assumed that. So he said he had to get out of that highly dangerous situation. He said he thought he was going to be killed. And so he then moved in front of the window.
And I understand that that's what he said, but that's a jury issue, Your Honor, because if you take,
nobody disputes that.
right, because at the point that if he says that he had the right to shoot to kill regardless of
No,
what
he didn't say he had a right to shoot to kill. He said, I instructed him to drop the gun. He didn't comply with my order as far as I understood. I was in a vulnerable position behind the door. I couldn't see. The guy had cocked the gun and he knew he was there and he had to get out of that place, which was a place where his life was at risk.
The difference in why there's a genuine issue of fact is, what does the officer see after that? First of all, he gives him no time to comply. Mr. Nibbs is motionless and not threatening and not saying anything and not doing anything. And
So
not
that
making
argument flies in the face of the case where we had Justice Powell wrote the opinion where the person that they thought it was a gun and it turned out to be not a gun, or where the knife was being approached in Sigmund, or the recent Supreme Court case where it was a hammer, a guy grabbed a hammer in a garage and was coming at the officers. These cases all indicate, the question is, the officer has to think quickly. He doesn't have to subject himself to a life, a potential life wound coming at him. It all develops quickly. And the question is, did he act unreasonably, or would a reasonable officer have thought at that moment that he was violating the Fourth Amendment?
You know, I believe he would, because the difference between Sigmund and Slattery and all those lines of cases is that the officer sees movement, sees something happen that causes the officer to feel threatened. In this case, all the homeowner did was walk from the bedroom and stand 6 feet behind a closed door with his gun in a safe position.
He was ordered to drop the gun. He didn't drop the gun. And now the officer thinks he's ready to get shot. Now, that's the critical facts from the officer's point of view.
Right, but a reasonable officer would give Mr. Nibbs an opportunity to comply with this instruction that Sheriff Holland said he didn't have to comply with. A reasonable officer would know that a homeowner doesn't have to disarm himself based upon an unknown person yelling sheriff's office one time and put it down twice. So that's what
this sheriff's office one time is really contrary to the evidence. As a matter of fact, Freeman heard several calls, but quite apart from that, Freeman was not even being consulted when the sheriff went the first time and yelled twice and pounded on the door, and then came back and did it in repeated times. And everybody heard that. But regardless, it's undisputed from the officer's point of view that he was trying to get the attention of the person in the house. And at first he thought there was no one there, and then he knew somebody was there and he went and repeated that. And that was heard by everybody. The whole point of my questioning, and I'm going to back off. I'm going to give you a few extra minutes to respond. But the whole point of my questioning you with this intensity is that we have to start from the officer's point of view and decide whether a reasonable officer in that position would have thought he was violating the Fourth Amendment. And that's the test under the immunity.
Right. And I think a reasonable officer knows that he may not shoot a man inside his house who's motionless and who has only loaded his shotgun and hasn't made any threats. A reasonable officer knows that under the Fourth Amendment. That's what Cooper says, and that's what Hensley says, that if the gun is in a safe position, mere possession is not sufficient to justify the use of deadly force. The officer knew that. Thank you, Your Honor.
Okay, thank you. I didn't want to take up all your time, but I was be happy to give you another minute if you had something more to say.
No, I've got 5 minutes in rebuttal, I believe.
Okay, we'll come back to you.
Yes, sir. Thank you.
And we'll hear now from Mr. Bader.
Good morning, and may it please the court. Stephen Bader from Cranfield, Sumner, and Raleigh, here on behalf of the defendant appellees. I'm going to dive right into the 1983 qualified immunity section of the argument here, given where some of this initial questioning is gone. When we look at this court's precedent in deadly force cases, what it teaches is that when an officer identifies themselves, when the individual that they identified themselves to presents some risk of physical harm to the officer or to others, certainly in situations where the officer has reason to believe they may have a weapon. And then third, the officer offers some type of an instruction or a direction to try to diffuse the situation, and the individual does not comply, that the officer does not have to wait to see if the individual intends to shoot first before deadly force may be used, and qualified immunity would attach. And
all that's true as a matter of black letter law. I don't think anybody contests that. But the question in the qualified immunity context is whether there's an immediate threat of harm, and is there a factual issue that's involved. And that's my concern in this case. It's the dead of night. There's no light anywhere. The officer may not be able to see, but there's no indication that the homeowner can see. And he's done, the homeowner's done what I would say nearly every homeowner would do when he's faced with that sort of disturbance. They have a defensive firearm, and they're trying to find out what's going on outside their home. So you have this factual dispute as to at the time of the shooting. The deputy says, well, the gun was pointed, availing factual evidence here, that based on the wound pattern, maybe the jury believes that, maybe they don't. He had to be standing somewhat like this. And there's an awful lot of homeowners who would be doing exactly that, faced with these circumstances. The blue lights aren't on. I don't think we can assume that the homeowner knows for sure it's a police officer. I think the widow testified that he didn't think it was a police officer. And that seems to create a jury question that would go to the credibility of the witnesses. And in that regard, you know, looking at the investigative interview where the Deputy Mumford testified, he said that he didn't know if Mr. Kibble's firearm was shouldered. I don't know if it was shouldered. I don't know if it was under his arm. I know he was standing canted to me, which would be this position, that someone could usually shoot from. But if that's your evidence, why isn't this a factual dispute for the jury?
Well, Judge Agee, that was a lot for me to digest, so let me make sure I can be responsive. I think to the critical question, where the gun was pointed, that's not dispositive. The question is, how would a reasonable officer react to the circumstances, being that they announced...
Well, on the contrary, that may be dispositive. I mean, it's not open season for a frightened police officer to shoot an innocent homeowner in their own home because he's afraid that someone who's not pointing a gun at him might, at a later point in time, do that.
But what's critical here is that he has identified himself, he has gone to the door and knocked, and what he's been greeted with in response is the sound of a shotgun shell being forced into the chamber. And when we look at the cases that Mr. Nibbs and his counsel relied on, Cooper, Pena, and Hensley, those cases do not involve those critical facts. In those cases, the officers did not announce their presence. In those cases, they encountered a homeowner who had a weapon that, I believe in all three of those cases, was not directed at the officers. And then with no direction, warning, command of any kind, the officers react by shooting the homeowner. And the critical facts in those cases and why qualified immunity became a jury question is turns on that. That is distinct from the cases that we cited, namely Slattery and Russell, where an officer has identified themselves to an individual. But
in all those cases, including the one that just came down for the Supreme Court, there's something furtive being done by the person who got shot. They're coming at him with a hammer in a position to strike. They're reaching for something that turns out not to be a weapon, but they're doing something. Whether they're reaching for a knife or they're reaching for a can of beer, or in one case, the guy's reaching for his Walkman. But here, my question goes to, here you have a plaintiff's evidence, which is that the guy's just standing there. He's not pointing the weapon. There is no furtive movement under the plaintiff's evidence.
That may be true, but I would take the position that a furtive movement isn't necessarily the critical question. I mean, the question, again, from the officer's or from the perspective of a reasonable officer on scene, is whether there's probable cause to believe that that person presents a risk of physical harm. I don't think that necessarily requires a furtive movement. In this case, we have an individual that, again, racked a shotgun or a shell directly into the chamber of their shotgun after the officer announced themselves. That is a deliberate action that was taken. That type of action was not taken in Cooper, Pena, and Hensley, and that further distinguishes this case from those cases. And to Your Honor's point, referencing Slattery and Russell, you had an officer that had identified themselves that was dealing with an individual that they had reason to believe had a weapon that was not pointed at them, at that point would have been concealed. They make a direction to that individual to comply, if for no other reason than to try to diffuse the situation, and the individual does not respond to the command, which lines up neatly with the facts that we have here.
Well, counsel, I think one fact that doesn't line up neatly, and I asked your opponent about this, is that the officer can't see what is going on. The person he's coming to talk to is inside his own home in the dead of night, and he brings a loaded weapon to see who's at the door. Your position, I take it, is your response to Judge Agee's questions about it not mattering the position of a gun. I take it that your position is, if an officer announces himself and hears a shotgun rack and has no reason to think that the person has set it down, although he can't see, then it's reasonable for him to assume that he's being hunted and will be shot imminently, and he can therefore shoot to kill. What am I not tracking there? And is that your position? And if so, how is that reasonable?
Well, I wouldn't say the being hunted and use some of the terminology that Your Honor used in her question, but I think it's more than just that, which is that at that point, when he perceives that he is in danger because he's heard the shotgun rack and he's not getting a response from the individual on the other side of the door, he doesn't have to wait to be shot. But what he does...
But is he, I mean, there's a rock wall. I looked at the pictures. This is a stone home, right? There's rock walls and a solid door. And he heard the shotgun rack before he stepped on the porch, right? He's about to step onto the porch from the stairs. Is it reasonable to assume that your life is in danger at that point and I take counsel's point, when a homeowner in rural North Carolina in pitch black is bringing a defensive weapon to the door?
But I think we have to look at really what happens next leading up to the shooting, which is that the deputy makes a decision at that point to try to get off the porch using what he believed to be the safest way off. And when he does that, there is no dispute that what he sees is an individual that is at minimum possessing a firearm, and that is clearly not complied with the direction, and that previously, after he had announced himself, put that shell in the chamber, indicating at least some potential intent to use his weapon.
Counsel, it might be useful also if you were to note that leading up to this is not just a homeowner trying to protect his house. The conclusion would be just the opposite, because this person had laid out boards which the officer reasonably believed had nails in it, that there had been a dispute, that this man was intoxicated, and he was in basically a rebellious state with respect to his neighbor. And so you're coming into a circumstance where now he refuses to answer the door. And then when the officer discovers he's there, that's even a more indicative situation where the guy is holding up. And he then comes down and doesn't obey the order, doesn't respond, saying, I'm complying or whatever. He basically stands behind the door. The officer can't see. That's the big problem. And he knows the gun's been loaded, and he knows the man's not obeying the officer's order. Those are the undisputed facts that the officer faced, not an innocent homeowner sleeping at night in Western North Carolina.
And I would agree with that, Judge Niemeyer, and also point out that those facts are further distinct from the case law that's been briefed before the court. And I just want to mention one other case.
The Supreme Court has relied on that. As a matter of fact, it always discusses that lead up. I mean, the officer's making a judgment call, and he doesn't have to put his life in the line when he reasonably believes his life's at risk.
That's right. That's right. And I also cited to this court in my brief, Elliott versus Levitt, a 1996 opinion from this court. It has a critical factual distinction, which is apparently in that case, the suspect, via that we don't second guess officers in the field. But in that case, you had a suspect that was handcuffed in the back of a squad car in response to a DWI arrest. The officers are outside of the vehicle and see this individual moving something behind his back, suggesting that he's looking for a firearm. And the court specifically says there, well, the fact that there is a car window that may be in place doesn't necessarily preclude the officer or reasonable officer in that circumstance when they've identified themselves. And there was also a warning in that case. A warning has been given and the individual is not complying, the deadly force may be appropriate. I don't want
Counsel, am I correct that Deputy Mumford testified that when he turned the flashlight on, that Mr. Knibbs was pointing the shotgun at him?
I believe that's correct, yes.
But there's also what the deputy told the investigating officer, that he didn't know if the gun was shouldered. He didn't know if it was under his armpit. Doesn't that create a credibility question that ought to go to the jury?
It does not, Judge Agee, for the reasons that I've argued, which is you're still asking how a reasonable officer in that circumstance, what they would perceive. And for all the reasons we've discussed, at minimum, he's got an individual who is not compliant with his direction, who is possessing a firearm, and who previously had made some use of that firearm in the form of racking the shotgun to suggest that he may intend to use it. I don't want to lose this thread if the panel has any more questions, but I do want to make sure I touch on the state law claims before my time expires. I'll try to hit on these claims effectively here with the time that I have left.
Well, don't they follow the conclusions with respect to the federal claim? In other words, once you have a conclusion that the officer is not reasonable or that he's reasonable, don't the state claims rise and fall on those?
I think that they do, Your Honor, but there is some argument that at least the state law tort claims where there would need to be a showing of malice to overcome public official immunity, at least from Mr. Knibbs' perspective, is a somewhat different standard. I don't think that this court needs to resolve that legal question. For all the reasons that we've discussed, there's no malice. But in addition to that, when the court looks at North Carolina precedent on malice, you've got an officer who is acting contrary to their duties and who intends to injure, judged from the subjective intent of the officer. And in addition to all the facts that we've referenced, there is no racial bias involved in this case. There's no socioeconomic bias involved in this case. These individuals do not know each other. They have a very brief, unfortunate, and tragic exchange. There's no ongoing.
Counsel, the Bailey case, we quoted North Carolina law to mean that an officer acts with malice when he does that which a man of reasonable intelligence would know is contrary to his duty. So where do you get this additional requirement of racial bias and all that stuff?
It's not an additional requirement. So if I misspoke, that was not my intent. But in some of the case law, Doe versus Charlotte, a recent North Carolina Court of Appeals opinion considering malice, the court said, well, these are the facts that we're looking at here that have been presented to us.
But do you agree with our quotation of North Carolina law that malice is established if an officer acts contrary to his duty, knowingly acts contrary to his duty? Or with a man of reasonable intelligence would know, an objective question.
I certainly do, Your Honor.
Okay.
And of course, building on that, with an intent to injure, judge subjectively against that particular officer. And I want to.
What about, let me ask you specifically about the surety bond
Thank you.
claim. I mean, that's a small dollar amount claim, but does the plaintiff have to prove malice and wanton acts in that circumstance, or is that just a pure negligence standard?
In this case, they would have to show that Deputy Mumford would not be entitled to public official immunity on the state law claims. And here's the reason why. And as I was going through my briefing in preparation, I wished I would have been clear on this, so I'm glad I get an opportunity to address it. The public official immunity, the official capacity claim against the sheriff and the bonds rises and falls solely on the theory that the sheriff is vicariously liable for the deputy's individual capacity claim. If you look at their brief, section 3B, that is the only issue that's raised. And I mentioned that because I also pointed out in our briefing that there were other theories of liability that were pleaded and litigated at the summary judgment stage, but they were all waived on appeal. So the only argument that's been raised on appeal is, again, this official capacity vicarious liability theory. So they really will rise and fall together. If they're, because the deputy has public official immunity for the individual capacity claim, the sheriff cannot be liable for the official capacity claim, and by extension, there can be no recovery against the bonds.
So are you agreeing that if we don't think there's qualified immunity here, so there's not public official immunity at this point, that the $25,000 surety bond waives the sheriff's immunity or waives sovereign immunity to the extent of the surety bond?
I am, yes.
Okay.
And then last, I just want to briefly touch on and clarify the state law constitutional claims, the quorum claims. And really the distinction here is between sovereign immunity and public official immunity. In the Craig versus New Hanover case, the defendant had governmental sovereign immunity. You cannot get to the courthouse steps against that particular defendant. And so in that analysis, the North Carolina Supreme Court said, well, you may be able to bring a direct constitutional claim because of that governmental immunity. But if there is a potential for an individual capacity claim, that gets you to the courthouse steps. Now that claim may be barred because the facts show that public official immunity attaches, but you set out in our brief that the Court of Appeals, North Carolina Court of Appeals, did in Devon, follows from another case called Wilcox and then Russillo. For the reasons that have been argued, we'd ask that summary judgment in this case for all of the defendants' appellees be affirmed. I see I have 30 seconds left. I certainly am happy to answer any further questions the panel would have. Otherwise, I thank you for your time this morning.
All right, thank you, Mr. Bader. Mr. Melrose?
Thank you, Your Honor. Let me point out a couple quick things. First, I believe I hear Mr. Bader say that at minimum, the case is remanded back for a trial since governmental immunity has been waived at least up to the amount of the surety bound of $25,000. They briefed just the opposite, but I hear him say that today. That's the Lee versus Seaboard case, Your Honors. That case said the defendant in Seaboard admitted that governmental immunity was waived by the purchase of insurance in that case. We have purchase of insurance in this case with the Ohio Casualty Bond. That's pure negligence and gross negligence and negligent excessive use of force. It's the Lee versus Seaboard case. So we get a trial at least on
right, that. But your insurance, putting the surety bond aside, your insurance policy has a specific exemption in it. And my understanding was the North Carolina court said that exemption was valid. So if that's the case, you're just looking at the surety bond as a possible recovery.
I think that's true, Your Honor, except for a separate question, which is not right for the court's hearing today, is whether a limit of $25,000 is an adequate state remedy. And that's a separate case for a later date if there's a verdict in the plaintiff's favor. Let me also point out footnote 4 in the Lee versus Seaboard case explicitly says, even if there is no violation under the Fourth Amendment, there may be liability under North Carolina law. North Carolina law, then, this case still goes to trial under North Carolina tort law. Wilcox versus Asheville clearly allows us to go to court on the state tort claims of excessive use of force, as does Lee versus Seaboard, which recognize the same principle. One other thing I would like to point out is when we talk about the objective officer standard and what he knew and the information he had, our evidence is that Deputy Monford was thinking in a delusional, irrational fashion. As soon as he heard that shotgun being racked, he says, I knew he was going to use it. And that essentially game over at that point for Mr. Nibbs as soon as he racked the shotgun. Regardless of what happened afterwards, even though he's in rural Western North Carolina and would reasonably expect somebody to be armed and investigating. And remember, Your Honors, that earlier in the evening, there had been a dispute between Mr. Nibbs and Mr. Freeman about what had been going on with the driving too fast up and down the road and the boards and things like that. A reasonable officer would believe that the homeowner might very well suspect that the neighbors were coming down the hill to make trouble. There's no reason that he would expect an officer to be out there because he didn't see any blue lights, uniform, et cetera, et cetera. So Deputy Monford comes to this imaginary, fantastical belief that based on the racking of the shotgun, that Mr. Nibbs has now decided to kill him, to kill Mr. Freeman, and to kill every other officer who came to the scene. That's what he told the SBI within about 12 hours. And he uses colorful expletives to talk about his perceived animosity that's coming from Mr. Nibbs and how Mr. Nibbs was out to hunt him down and stalk him like prey and hunting him in the dark, none of which was true. And that's not reasonable for an officer who's investigating a civil right-of-way dispute where no crime had been committed. And he admitted that there was no probable cause for any crime at that point. The most that this could be is an attempted injury to personal property. So he's coming down to investigate basically a dispute that he can't resolve to talk.
Of course, that's irrelevant when we're talking about officer safety.
Except
an officer can simply be investigating. There are all kinds of hypotheticals or circumstances. So there's no issue here as to whether a crime was being committed.
I agree.
The sheriff came out to investigate a complaint.
Yes, sir. And I agree, except for under the state tort law, the totality of the circumstances and what our expert, Mr. Blum, says about the violation of police procedures and the escalation of this incident and the false sense of urgency and the fact that the deputy goes from a position of cover to a position of danger and tactically blinds him. That's basic tort law. And that is what Lee says and what Wilcox says goes to the jury on the negligence claims. Whether we're limited to 25,000 or not is a separate issue. We think we go forward on just as Judge Agee wrote in the Hensley case, when there's a factual dispute about which way the gun is pointing, the decision whether to shoot to kill that Deputy Monford made is at the time he shoots him. So if the gun is being racked and then these instructions, put it down, are being given and there's no time to comply, the next thing that happens is he sees a man that's not pointing a gun at him. He sees a man who poses no threat. So if we examine at that time and the jury gets to parse those facts, then we get to go to the jury to establish that the officer could not have reasonably believed that there was a threat to his safety at the time that he pulled the trigger. And then beyond that, he didn't tell the truth about what he saw, or he didn't understand what he saw because he tells various stories about it. Thank you very much.
All right, thank you, Mr. Melrose. I want to thank counsel for their arguments. Our practice would be to come down and greet counsel. We obviously can't do that. So our thanks and greetings will have to suffice for today, but we welcome you back to the Fourth Circuit.
Thank you very much.
Cases, right. We'll proceed on to the next case.
Judge Niemeyer, can we take a short recess?
Let's take a short recess.
Good morning, Your Honors.
Excuse me. I just, is it real Muto?
Yes, that's correct.
Okay, we'll hear from you first.
Thank you, Your Honors. Good morning. May it please the court. Trina Real Muto on behalf of plaintiff appellant Youngfrey Gee. This at issue in this case is whether Army Specialist Gee obtained prevailing party status under the Aegis statute when he obtained an order from the district court that ended USCIS's 2.5-year delay in adjudicating his naturalization application. Under 8 USC 1447B, a district court is authorized to remedy a naturalization delay of more than 120 days.
Well, did the order that he obtained really do that? I mean, it just told the revested jurisdiction with whatever the agency is, and it said, well, you can do this in 45 days, and if you don't, then it comes back to me to decide. I mean, that didn't really end anything, did it?
Absolutely, it ended it because it adjudicated the 1447B claim, which was to force an adjudication of the application. And under
but wouldn't you say the merits of the case was whether to grant the application for citizenship or not? That's the relief he was seeking in the complaint. He asked the court to order the application to be granted or to remand, of course, with instructions to have it granted. Now, the court could have directed the agency to grant the application, and that might help your case, but the court basically said to decide it. And let me ask you a hypothetical. What if the agency then, within the time period specified by the court, denied the application? Would you then claim fees?
At that point, I mean, if the order, which it did in this case, imposed.
No, my hypothetical.
I would, because it doesn't matter if you prevail.
The court says, I'm going to send it back to the agency to make a decision within 45 days. And the agency makes its decision and denies the application. You think you would be entitled to fees?
Yes, because if I may,
it's not a judgment on the merits. The judgment on the merits was to deny the application.
Correct.
What you did is you wanted to facilitate the processing of the application through 1447B. Congress said if they don't act within a specified time, you can get the courts to force the decision. And that's what you did. But I guess the question I'm having is whether the court's decision was on the merits or whether it was a procedural decision telling the agency to decide it on the merits.
Well, if I may, Your Honor.
Yes, of course.
1447B only affords the district court two forms of relief, either to adjudicate the application or to remand. Now, if a person can only become a prevailing party if they win adjudication, that would mean that Congress passed a statute that categorically denies prevailing party status to anyone who wins that other form of relief under the statute, which is remand. Now, USCIS had an obligation because the district court's order, it didn't say it may adjudicate it, it said it must. And that's in the record in the district court's order. So it imposed an obligation that the agency otherwise didn't have or face consequences.
But the agency didn't have to adjudicate it because the court said, look, and if you don't do it, then they'll come back to me and I'll do it. So it really wasn't anything enforceable that I see in that order. There wasn't any penalty if the agency failed to adjudicate. It just came back to the district court.
So we would argue that he obtained actually both forms of relief that are available under the statute, because in retaining jurisdiction, the court's order complies with the qualitative inquiry that's required under Buchanan, which is a change in the relationship because it imposed an obligation on CIS.
Well, Buchanan defined the material alteration of the circumstances to be two things: to get an enforceable judgment on the merits and to have a consent decree with judicial imprimatur. So there's argument that there could be some other things, but that's all the Supreme Court's ever talked about, and that's how they define the circumstances. in Buchanan. So my difficulty here is that I don't see anything first that's enforceable, and I don't see that there's any judgment that approaches the merits.
Well,
so, I mean, to me, I mean, how is this different from just a scheduling order in a case in general?
Well, it's different from a scheduling order in the sense that a scheduling order doesn't resolve the merits claim on the merits. In this case, the district court judge looked at the merits claim. The court analyzed his case to 3 other cases involving delayed background checks and found that there was a delay here sufficient for the court to order relief. Now, with respect to the judicial imprimatur, apologies.
So, but what's the relief he got?
The relief he got was he got USCIS a deadline that it had to comply with, judicial consequences if that deadline wasn't complied with, and
What's your what?
The court stayed the case and retained jurisdiction and said, if you don't comply, USCIS, I will adjudicate this application. And that is the enforceability that we believe satisfies Buchanan.
So, but I don't understand how that's enforceable. It just says, okay, agency, you got 45 days. If you don't do it, then I'll do it. I don't see how that gives him any kind of an enforceable remedy. He already had that. I mean, the court could have adjudicated it right then.
Well, the court didn't have to because it had the option of one of the 2 different forms of relief. But I pose this to you, Your Honor. What if the court had said, we're going to remand with instructions, USCIS, you have 45 days to adjudicate this?
Well, you can pose the question to yourself because it doesn't work that way in this setting.
Sorry, apologies. But my point is that a plaintiff could come back to the district court to enforce the court's order. But here, the district court said, I'm going to stay the case so that you can come back to me if I'm notified of noncompliance, and then I will adjudicate the application.
You keep using the word adjudicate the application. Isn't that what the merits are? In other words, the merits is a decision on the application. And
no, that's the relief, Your Honor.
Let me just finish. And the statute is a procedural benefit that you get to avoid bureaucratic delay. Congress said basically if there's insufficient time, if the agency didn't act within a sufficient time, you'll get assistance from the courts in getting it decided. But the decision on the merits is the decision on the application. It seems to me, it's a little telling that you would, even if he lost on the merits, you would still ask for fees because of the delay. So you'd basically want delay fees as opposed to being successful on the merits.
Because we believe that the claim is about ending the delay in adjudication and forcing USCIS to act, because that's what the 1447B statute is about. And 1447B doesn't say the district court has to adjudicate the naturalization application. It says you have 2 forms of relief. And if you win either one of those forms of relief, we believe you're a prevailing party.
What if the district court issued a writ of mandamus to the agency and said, decide this post haste, no later than 30 days?
I believe that is what happened in one of the cases.
Just a minute. Would you get fees is my question.
Yes, you would, because that was an obligation.
Court issues a mandamus and it doesn't resolve the case, just tells the agency to decide it. You say you get fees?
Yes, and in fact, Your Honor,
I don't know how you square that with Buchanan, but.
Well, that's what I believe the 10th Circuit or the 11th Circuit held in Al-Maliki, where they issued a mandamus and the court still found that that was prevailing party status, because as the cases that have found prevailing party status in the 1447B context have held, that date certain imposes that obligation. And the retention of jurisdiction poses the judicial imprimatur, that judicial oversight. And that's not me saying that. That's the 15 or so cases that we cite in our briefs that stand for that proposition. Now,
counsel, let me look at it in a slightly different way. Looking at the relief that Mr. G requested. So in his complaint, he wants the agency to adjudicate the application immediately and for the court to schedule an oath ceremony by a date certain, or an order compelling approval of his application, prompt administration of the oath ceremony, and lastly, promptly administer the plaintiff's oath ceremony, depending on which particular count you were looking at. So he didn't get any of that. He got a remand without any specific direction except timing, and he opposed that because in his status report he says he does not agree to the government's offer of an agency remand, and he says if the court does give him a remand, it should only do so with explicit instructions to schedule the oath ceremony within 21 days. So he didn't get anything that he asked for.
Well, with respect, Your Honor, the complaint also asks for any relief that the court deems just and appropriate. And he does ask for remand in his complaint under 1447B. And he consistently, of course, he advocates for adjudication. That's his first position. But he still wins some relief from the court because his alternative position for remand is made both in his complaint, his opposition to the motion to dismiss, and to his status report. And he wins that relief. And the court goes beyond what he asks for.
Right, but the remand that he got, he opposed. And your position seems to be that, well, you can get attorney's fees for relief that you didn't want.
He did want remand. He asked for remand. And the court had authority to order remand with appropriate instructions.
But he says that he doesn't agree with the remand that the court ordered. And he only wanted remand if he could get an oath ceremony within 21 days. I mean, that's verbatim from his pleadings. Well, and it just seems odd to me that you can be entitled to attorney's fees for relief that you were opposed to.
For relief that you won on a claim under the statute, which gives the district court the authority to impose instructions with respect to the remand. So by bringing the claim, he sought to end the delay. And the district court had those two options to remedy delay. It selected the remand option, which he consistently asked for throughout his pleadings. Was it exactly the same? No, I understand Your Honor's position. But the fact of the matter is that
I don't have a position. I'm just reading from the record and asking questions.
But for the district court's order, USCIS would not have had that obligation. And that brings me just to the point that USCIS claims that it had a voluntary change of position, but we would submit that it did not because that position wasn't voluntary. The source of the delay, which was enhanced background checks, was found by a district court to be arbitrary and capricious. And only after that finding did the agency come back and say, hey, we can commit to a date certain. But at that point, that voluntary change is immaterial because jurisdiction vested with the district court under this court's decision in ATAP. And the district court, USCIS couldn't force the district court to do anything at that point because the district court had jurisdiction. And in fact, the district court went beyond what USCIS was sort of saying that it would do because it said, it's not enough that we're going to send this back. I want to know if this doesn't happen. Because if it doesn't happen, come back to me and I'll adjudicate the application. And I'm giving you judicial oversight by staying in this case, by keeping it open so that I can make sure that my order is enforced. And so with respect to the voluntary change position that I expect that opposing counsel will argue, we would just clarify that it's not, in fact, a voluntary change. And if it is, it's just not material. Now, I'd also just, in my remaining minute before I sit down, I am sitting down, I'd like to point the court's attention to the decisions from the 10th and the 11th Circuit that have held that these types of orders are exactly the types of orders that can convey prevailing party status. And if this court goes in a different way, it is actually bucking up against what those two circuits have held. And so I think the weight of authority is in our favor in this case.
You do agree, don't you, that Buchanan governs our application of the statute?
I do, and we think the fatal flaw in the district court's decision was he read this court's decision in Goldstein to narrower than Buchanan, and we think that's inconsistent with the court's decision in Smythe and Grissom, which requires the district court to undertake a qualitative inquiry into the nature of the order. And that didn't happen here because the whole holding of the district court, according to the opponent, is in a footnote of the decision, and there was no qualitative inquiry. I see my time is up.
All right, thank you, Mrs. Yamamoto. Mr. Hambrick?
Good afternoon, Your Honors. Can you hear me okay?
Yes, you're fine.
Thank you. Your Honors, Jonathan Hambrick on behalf of the defendants appellees. It is our position that Buchanan established two conditions and which are necessary to be a prevailing party. One is obviously an enforceable judgment on the merits, and the second is a judicially enforceable consent decree. That was established by the Supreme Court in Buchanan. That was upheld by this court in Goldstein, Hart, and Smythe. It's also the opinion of the First, Second, Fifth, and 10th Circuits Court of Appeals in 1447B cases. Those are all cited in our briefs. So it is the majority opinion and the binding Supreme Court decision that the only two conditions that can satisfy confer prevailing party status are an enforceable judgment on the merits or an enforceable consent decree. Now, we can eliminate consent decree from the outset because plaintiff never agreed.
Sorry, counsel. Sorry. Where do you get only? Where did the Supreme Court say only? I thought they said these are examples. Am I misreading it?
The Supreme Court did not use the term only, although those were the only two examples.
It used the term examples, right?
I'm not sure about the word examples. I know they didn't use the term only, but they used those as examples, so it's equivalent. But this court, the Fourth Circuit, in both Goldstein and Hart, did use the term only in decisions that were 3 years apart. Now, plaintiff characterized that as a Scrivener's error, and it's doubtful to our position that the Fourth Circuit would commit the same Scrivener's error on two occasions 3 years apart. But that's
Hart's not published, so that doesn't bind us at all.
Correct.
And Goldstein actually definitely used the word only, but then went on to talk about whether there was an exception. And the whole point, the whole question in that case was, is something else potentially an exception here? And the court didn't rely on the idea that there's only two categories and this doesn't fit a category. The court was assessing it under, a different sort of analysis. So I don't know that you need to win on this, that we've handcuffed ourselves to only two particular categories, but I think that's probably your weakest point from my perspective is whether we're, constrained to these two things when the Supreme Court and CRST recently has emphasized that what matters is a change in the parties' relationship and judicial imprimatur.
Absolutely. And while I think it is correct that those are the only two things that do confer prevailing party status, that is not the only peg on which we're hanging our hat. There are several reasons why this is not a judicial decision on the merits. We can start with the fact that 1447B it's essentially a jurisdiction granting statute. So it says, district court, you can decide this decision, issue a decision on the naturalization application, or you can remand it to the agency. So when plaintiff says that they obtained one form of the relief they sought, they would have obtained a form of relief they sought simply by the district court saying, I have jurisdiction. And in fact, that's in their prayer for relief. Their first prayer for relief in their complaint is to have the district court assume jurisdiction, which it did under 1447B, obviously. But then you also need to look at the language of 1447B to find out what the merits are. And if you look at 1447B, it repeatedly says the district court has jurisdiction over the matter. It may determine the matter or remand the matter. So it's our position that the use of the word matter has meaning. That is obviously a decision on the naturalization application itself. It's also, in Buchanan, the court also said we need to respect common language and understanding. And it's hard for me to understand how plaintiff can claim to be a prevailing party when he opposed our motion to remand. It was unpalatable, it was insufficient, it was several other adjectives he used.
I have a question about that, because I do think this is an important point. So Guy did, in his complaint, he requested for the court to decide his petition for relief. But he also said that if the court didn't do that, he asked the court to remand to require the agency to adjudicate the application immediately and schedule an oath ceremony by a date certain. So he didn't get the oath ceremony and he didn't get the immediately, but he got an order remanding requiring the defendants to adjudicate the application within a certain period of time. Is that enough to have prevailed in some sense, that he got some of the relief he sought, but not all of it? Is that enough?
It's not enough, Your Honor, for several reasons. First, imagine if the district court had denied my motion to remand and the court said, I'm going to set it for trial. That order, which is essentially what all that this order did, would not be a judgment on the merits. Buchanan referenced several cases where they talked about winning a Rule 12.
Well, I'm not really, I think you do have multiple points here. And one question is this a judgment on the merits? And what are the merits under this statute? But the question I'm asking is more about if he obtains part of the relief he sought, is that enough to make him a prevailing party, assuming that we're talking about the merits? Because there was some discussion about whether he sought this relief at all, or whether he didn't want this relief, or whether he got anything he asked for.
The only thing he got was the opportunity to be heard, which was a right he already had the day he filed his lawsuit. The day he filed his lawsuit, there had been a delay longer than 120 days, and therefore by the express terms of 1447B, the court had jurisdiction, and either it could decide the merits or it could remand it to the agency to decide the merits. But that by itself isn't anything that would warrant a finding of prevailing party status, because that's simply the court saying, I have jurisdiction. That's one of those preliminary decisions, and there are a whole host of them in the cases we cited where the court said it's not enough. And it's also, to put a point on it, I'm not aware of any way you could consider that relief to be on the merits, simply a determination of who's going to make the decision in the first instance, when the outcome of that is a decision that's going to be issued de novo. I think the district court used the term in the first instance, and that was the case. That's the case here.
So and this is a fine argument to make. I just want to clarify. You're focusing on whether this was on the merits. I don't hear you disputing that he asked for this relief. He asked for a remand and he got it, but he just didn't get everything he asked for. He didn't get the date certain and for the oath ceremony.
I would submit that while he asked for it in his complaint, I would submit that number one, that's not sufficient. People ask for all sorts of things in their complaints. And number two, he may have asked for it in his complaint, but then he opposed the specific relief that it was granted. So he changed his position and opposed the remand for a decision within 45 days. So I don't think he should benefit by asking for something and then opposing it and then claim when the defendant's motion is granted that he prevailed.
Yes, and that's my question. So he asked for a remand to decide it immediately, and then the court said, or you proposed a remand to decide it in 45 days. He opposed that because he wants it immediately. And my question is, if the court says I will remand it, but only to give the agency 45 days, you think that wouldn't be prevailing?
No, it wouldn't be prevailing for a couple of reasons. Number one, I mean, essentially what he's arguing, their position is effectively a catalyst theory argument, that by filing the suit, somebody had to decide it, and we got a decision, and therefore I apologize if I'm not addressing the precise distinction that you're drawing. It is, in some respects, it's very fine distinction because they do merge together.
You can move on. That's fine. I just wanted to clarify. There have been some questions about, number one, whether it's on the merits, which is, I think, the bulk of your argument. But number two, whether he got anything he asked for, whether it's on the merits or not. And so I just wanted to clarify the second question, and that you've done a fine job.
Thank you. So as to the merits,
can I ask you a question? It looks like the statute is sort of a particularized mandamus statute, at least in part. It authorizes the district court either to take, it authorizes the district court to take jurisdiction of some matter that hasn't been decided, which is of course needs Congress to give that. But then it authorizes the court to send it back to the agency with instructions. And one instruction, of course, could be to decide it in a particular way, in which I think the plaintiff here might have a much stronger argument. But if the court just simply sent it back to decide it within a few number of days, is the issuance of a mandamus order within the scope of a decision on the merits, a judgment on the merits?
Not if the order simply says you decide it, as the district court said in this case, and if you don't, I'm going to decide it. That by definition, you can't, that's not a judgment on the merits because it's not deciding anything. It's simply saying issue a decision. And you have to look at whether this is enforceable. Well, what would have been the consequence if the
it's
CIS...
clearly enforceable. The court can tell them what to do. The question, I think, goes back to something that Judge Agee asked about. Was this nothing more than a scheduling order, a procedural order, or was this substantive relief, so to speak, changed the relationships of the parties under 1447B? That's the argument that the plaintiff is making.
Sure, and this is, in my mind, this is equivalent to a scheduling order setting a trial date, where the judge then turns to the parties and says, look, you have 45 days to settle this case, and if you don't, we're going to go to trial. That in no way could be described as a judgment on the merits. But that's effectively what the district court said. He didn't say, decide it within 45 days and grant it, and that would obviously be a very different situation. He didn't say, issue a decision within 45 days, and if you don't, then I am going to grant it. And he basically imposed only a timing deadline, and that is not on the merits. It simply can't be. There are all sorts of procedural orders that courts enter that are enforceable in the sense that the court can enforce compliance with the procedures, but you need to look at what the consequence of not complying is. Something like this, where the only thing that matters is that they issue a decision, and if they don't, we're back where we were the day before the district court issued its decision. The district court could have said, I'm denying your motion for remand, and I'm going to set this for trial. And I don't think anybody on this here would argue that that was a judgment on the merits, simply setting it for trial and retaining jurisdiction to decide it. And that's effectively what happened. It was an opportunity for the parties to resolve the matter without the need for court intervention on the merits. And that's what happened. The defendant voluntarily changed its position in response to what happened as an external event in NEO, which happens all the time. I mean, that's Buchanan, the West Virginia Supreme Court or West Virginia legislature changes the rules, so the parties change their position. That is a voluntary change in position and the catalyst theory that the Supreme Court rejected in Buchanan. I think the most analogous case that this court has decided while unpublished is Hart. I mean, in Hart, it was an ERISA case where the court remanded it to the fiduciary and said, issue a decision within 30 days and consider all of the evidence I decided after it had considered cross motions for summary judgment. And this court said that was not sufficient. So my view is that a generic remand order that says issue a decision within no further instructions could ever be considered sufficient to confer prevailing party status.
That it?
Do you want to address? Oh,
go ahead. No, fine. Go ahead.
I am happy to address any questions.
Your opponent says that if we agree with you, we'll be, if not creating a circuit split, we'll be creating disharmony among the circuits potentially. What's your response to that?
Well, I would say that there already is a circuit split. We have cited cases from the First, Second, Fifth, and 10th circuits that essentially rule that our position is correct. Plaintiff has cited a 10th Circuit case and an 11th Circuit case. Their 10th Circuit case is very easily distinguished because in that case, the district court actually ordered CIS to grant the application. And the subsequent 10th Circuit case on which we rely said, we're distinguishing that situation from this situation. So the 10th Circuit falls the same way that our position is. The 11th Circuit is different, although that case we believe is also distinguishable because at least the court did issue a writ of mandamus. It's our position that would still not be sufficient and is an improper expansion of Buchanan and would be contrary to this court's jurisprudence, as well as the First, Second, Fifth, and 10th court's jurisprudence. But it is at least that split does exist. And there are district court cases from other jurisdictions that would hold plaintiff's position as sufficient. But it's our view that that's contrary to Buchanan, and it's certainly contrary to this court's jurisprudence. Unless there are other questions, I'm happy to yield the rest of my time.
Thank you, Mr. Hembrick. Ms. Muto, excuse me.
Fine, Your Honors. I just like to make a couple of quick points. With respect to Judge Rushing's question about some relief, how much relief is enough to confer prevailing party status, we think that's answered under Buchanan and this court's decision in JD, which just says some relief. It doesn't have to be all relief, and it doesn't even have to be the central relief at issue in the case. With respect to this discussion about a circuit split and circuit authority, well, quite frankly, I don't think you have a circuit split when you're relying on unpublished decisions, and the Second and Fifth Circuit decision, which opposing counsel references, are both unpublished. We think the First Circuit's decision and the 10th Circuit's decision are absolutely distinguishable here. In the First Circuit case, there was just a short docketing order remanding with no instructions, and the parties jointly agreed to remand, and there was no obligation on the agency to do anything. In the 10th Circuit case, we think that bucks up against our published 10th Circuit decision, which is more akin to the facts here.
Is the 11th Circuit decision you rely on, is that the unpublished opinion in Abdel Galil?
Yes, Your Honor. That is the one that is about the writ of mandamus. But we have the 10th Circuit's decision in Al-Maleki, which is very similar to the case here. And if I may, we also have the weight of the district court decisions analyzing orders exactly like this and ordering far less relief.
Well, opposing counsel says that the 10th Circuit has distinguished that case in its later cases.
Well, the 10th Circuit's decision in Iqbal, it distinguishes the case, but in the Iqbal decision, it was one of those hypotheticals that the court posed where it was just a remand with no instructions to do anything, and there was no obligation imposed on the party.
The distinction, at least as counsel has, Mr. Hambrick has pointed out, is the distinction I made in questioning you earlier. If the district court issued an order to the agency to grant relief on the merits, to me, that's distinct from remanding to the district court and saying decide it. In other words, the first one, the district court is taking a position, which is to decide it on the merits. In the second hypothetical, the order would be just telling the district court to the agency to decide the question. And as I understand the distinction in the 10th Circuit cases, is the first case was a decision to grant relief, which would be analogous to getting on the merits, where the second would be more like a mandamus, which just tells you make a decision. Is that your understanding of the two cases or not?
Well, my understanding is when a district court orders relief under a mandamus, that issuing relief under
no, stick with the two cases. Did I misunderstand the two 10th Circuit cases? The first one directed that relief be granted, right?
Right.
All right, now that's distinct from sending it back and just saying decide the case. Because when the court tells the agency to grant relief, it's made a decision on the merits.
But it hasn't. But it is invoking that second part of the 1447B statute, which is remanding to the agency to determine the matter. It is not
if it directs it. No, not if it directs it to what the decision ought to be. No, it's one thing to tell the agency to decide it. It's another to tell the agency to enter a judgment for plaintiff or defendant, so to speak.
Well, I think the problem with that position, Your Honor, is if you are not going to
allow... I'm just trying to find the distinction in the 10th Circuit cases. And as I understand it, the first case indicated that the order was to grant relief. And the second case was not that.
Correct, but the district court in the 2009 Al-Maleki case, they granted the motion to remand so USCIS could administer the oath by a date certain. So they were imposing an obligation on the agency to act within a time certain, which is the material change of relationship that we're talking about.
Counsel, your opponent brought up a good question. Under what circumstances would you not be a prevailing party? If 120 days has passed, you file your complaint, under what circumstances would you not have prevailed under your theory?
If the district court had found that the delay was in fact warranted. But here in the record at pages 116 to 119, district court engages in the delay analysis. And in fact, our whole claim, the mandamus, the APA, and the 1447B claim is all about forcing a decision on the merits of the delay. That's what a mandamus does as well. And if I may, his opposition was opposition to having a remand with no supervision related to that order. That's what he was opposing. He wasn't opposed to remand overall. He just didn't want remand with no end in sight. So he wanted to be able to come back to the district court, which is what the district court ordered. And then, very briefly, if I may conclude, yes. I just encourage the court to appreciate that if this type of order cannot confer prevailing party status, it effectively means that categorically under 1447B, a plaintiff has to win adjudication in order to be a prevailing party. And we would submit that Congress could not have categorically denied a whole group of people who win on their delay claim from having prevailing party status. That would conflict with the intent.
Well, the distinction would be, just to accommodate the statute, the distinction would be whether the merits are decided, because every formulation of the rule that the Supreme Court has given has added the word "on the merits." And obviously, procedurally, you can change a relationship. And they gave some pretty significant changes of a relationship in connection with motions to dismiss, that type of thing. But they said on the merits was a requirement. And while they didn't use the word only, they did use the word only when they said we have only granted relief in circumstances where it's a judgment on the merits or consent decree. That was later when they were recapitulating. But regardless, I think the statute, the distinction that Buchanan reads on this statute seems to be something to the effect that if it's a procedural ruling that changes, it may not be compensable, whereas if it's a substantive ruling on the merits, that is on the application or the matter, so to speak. The story might be different, but we hear the arguments. We've let you have a little extra time. They were very good. Your arguments are both very good, and it's a question on which we probably ought to try to create some clarity in this area. It doesn't sound like, at first, it sounds like sort of mechanical, but it really isn't, as you pointed out in your argument. We normally come down and greet counsel at this point, and of course we can't, but our thanks for your arguments and our greetings to the Fourth Circuit will have to suffice this time. Many thanks and have a good day.
Thank you, Your Honor.
We're in court for the day.
Thank you.
Or till this afternoon.
This honorable court stands adjourned until this afternoon. God save this honorable